Hey guys, Rogue Nation here with you. And today I have the first case that I ever handled myself and won was a red light camera ticket. Now right off the bat you can hear me and the judge talking about recording because I had a recording device up at the podium. And this device here that we're going to be listening to and is looking up at the lights was a video recorder that my buddy brought in. And because he couldn't hold it up to videotape us, he just set it down so it could catch the audio. So all we have is the audio of this court case. It's a red light camera ticket, and I defended myself, and I won. So we're going to let this play. I'm going to pump up the audio on it so you can hear it a little bit better. And, leave me comments at the end. Let me know what you think. And we'll see you in the next one, guys. All right.
No, sir. It's audio. It's digital.
Well, doesn't have a tape to it.
No, sir.
You can't tape it. If you record the hearing, sir, you must leave the tape here when you leave.
I thought that was only if you weren't recording it.
No, sir. We are recording.
I understand that.
So you don't have to have it. You don't have to have it on recording because you can get a copy of the recording on tape from we requesting it from the county.
Okay, sir.
But you cannot tape something and
Am I reading this wrong then?
Sir?
Am I reading this Florida recording law wrong?
I'm telling you what the
Under court here?
I'm telling you what the statute says about recording in this court, sir.
What statute would that be?
I don't have a statute number. But you got the I'm telling you, you cannot record it unless you record it, but you must leave the recording here. And you leave it here?
Sir. Well, I can leave it here if necessary, but if I could...
Well, it's necessary if you record it. You have to leave the recording device here.
Okay, that's fine. I'll leave it here. Is it possible to...
What kind of recording device do you have? Show it to the court. That's a phone.
No. It's a mini tablet that has no phone capabilities.
And that's recording, and you can leave the whole thing here.
Absolutely. Can I go ahead and read them?
Do you want this device up there at the bench, sir?
No. Because this hearing is being recorded by the county.
Okay.
I'm not concerned with that recording, but he can't take it out of here with him when he goes.
Okay, I can't take that recording device from him. Only the court can.
You don't have to give it to the clerk. Give it to the clerk.
So I'm putting it into evidence?
Yes, sir. Yes,
Okay.
ma'am. Give her the recording device.
Is it still going to be recording?
Well, I'm not going to touch it.
Does she know how to turn it off when it's done?
To file it indefinitely for the proceedings.
Okay. Well, when we're done recording, I'll tell her how to
Give
turn
her
it off.
up. You don't get this back.
I understand that. She needs to know how to turn it off.
You'll open when you run down, won't it?
Yeah, I guess. I mean, if you want that to record whatever goes on back there with your clerk, absolutely.
All right, sir. You're pleading not guilty to the charge.
Absolutely.
All right, officer, you want to tell me about Mr. Max?
Yes, on date and time mentioned, our cameras captured this vehicle attached tab initiated correspondence with the registered owner. Vehicle is eastbound on 441 in lane number 1
left turn.
Yes,
Short, yeah.
it's council appointed.
Okay. What would you say was the, can I ask questions? Is there an officer who wrote the citation here, Officer Ruger?
He doesn't have to be here.
He doesn't have to be there. Okay. Is that according to who?
The statute says that the officer does not have to be here.
What statute? Is that the act, the Mark Mondell Act? I have it right here. What statute, where exactly does it say that the officer has to be here? We'll wait till I look at
What part are you talking about, sir? What part are you talking about?
He's wanting to know if why the officer who issued the citation isn't here.
The officer who reviewed the evidence, reviewed and testified.
He does have the right to testify, and I have the right to confront. Where is he?
On this, you do not have the right because it's the camera case.
Where does it say I don't have the right to confront him in this law?
I'm feeling here that says that the officer has the right, this officer has the right to review the film.
This officer does?
Yes, he does. And he reviewed the film,
Okay.
and that's what we're dealing with, is
So we can
what
move
the
it-
film shows.
Okay, we'll move right to questions then. Does the Papa owner rent these cameras?
That's immaterial to this. You know they're rented.
I actually did know they were rented.
I don't know where you,
Who does maintenance and testing on said equipment?
All right, well,
Anybody? Anybody with any knowledge of these cameras in the courtroom today?
first,
Is there anybody with any knowledge on these cameras, how they operate, or the chain of evidence of the courtroom today?
the act provides that the officer can testify, and the film can be introduced into evidence.
Is there anybody with any knowledge of how these cameras operate in the courtroom today?
So we have to put something else about it.
No. I move to dismiss for lack of personal knowledge. 90-20.
Your motion is denied. So what do you want to tell me?
U.S. Supreme Court case, Bull County versus New Mexico. As a rule, if an out-of-court statement is testimonial in nature, it may not be introduced against the accused at trial unless a witness who made the statement is unavailable.
That is a statement, that's not a
And
film.
the accused has a prior opportunity to confront that witness.
You've had plenty of opportunity. You got this citation last August. You've had plenty of opportunity to inquire before the case. You've got ample opportunity to do your work of discovery.
I've done my work.
Well, you didn't.
I've done my work so well that I know.
Did you attempt to take a deposition of the officer that signed the citation?
I don't have to take a deposition. If the man writes
What
me a
are you
citation,
telling me defense of this?
if this gentleman pulled me over on this road here and gave me the red light ticket, would he have to show up in court to testify against me? Or could this officer do it?
If it's not a camera case, you would have to show up there.
Okay, so we're treated unequally then?
No, you're not treated unequally.
In Arrington, first state, the statute then provides a rebuttable presumption that the owner was driving and allows the owner to rebut that presumption. Okay? When a vehicle is photographed or traveling 30 miles over the speed limit, there is no
We're
probable
not talking about
cause.
30 miles over the speed limit.
It's 27 miles over the speed limit.
We're talking about the red line, it's not the speed citation.
Okay. There is no probable cause to believe that the owner of the vehicle
Where are you
was
reading that?
driving. And therefore-
Where are you reading that from?
Dixon versus District of Columbia. Dixon versus District of Columbia.
Is it a Florida case?
It's a district court case.
Is it a Florida case?
No, sir, it's not Florida case. Neither is a Supreme Court
That
case.
has no effect upon me. It's not control the route.
Can I ask that some matters be judicially noticed here?
They're all being judicially noticed.
Then judicially noticed Dixon versus District of Columbia.
I don't know about the District of Columbia, but you notice that's part of state law.
Matters which may be judicially noticed, 90.202.
You're talking about the
6.
Illinois code.
Records of any court of this state or of any court of record of the United States or of any state, including D.C., territory, or jurisdiction of the United States.
It's pretty weak, yeah.
Okay. So can we judicially notice Dixon versus D.C.?
Well, they have judicially noticed when you brought them to the attention of the
So
court
now that we've
and referred to them. You have a copy of the case.
Yes, I do have a copy of the case. Would you like to see it?
Yeah, or you have to file it. You got to give it, you got to, in these cases you're signing, you have to give us a copy of
Can
it.
I give you all the cases I'm going to mention today?
Not until you mention them and call attention to what you're talking about. What,
Well, then, for the record, I'd like to judicially notice the state of Florida versus Arrington, Dixon versus District of Columbia,
what's the citation of them?
Dixon versus District of Columbia, 753.
You gave us the state of Florida versus Arrington. What about it? What's the citation of it? That was the first you mentioned.
Okay, we'll go back. State of Florida versus Arrington, 95 SO, got 3D 324 2012.
Alright.
Dixon versus District of Columbia, 753 F-sub-2D6 2010. Davis versus State, 90 SO.2D
What state,
629 1956.
what state is that?
State of Florida.
Well, you didn't say that, you said the state.
And I have Nielsen versus City of Sarasota, 117 SO-2D 731 1960. I have here people of the state of California versus Collide. All I have is the case number on this, and that is 30-2009-304893.
That was first file.
And go through all of these, the important parts of all these and where they're located at.
All right, what are the important parts of it? Which one are you reading the important part of it?
Okay. In Arrington at 327.
What part of it?
Pursuant to section 316.075, a law enforcement officer has to observe the violation, who then tickets the driver of the car.
What paragraph are you reading out of the Arrington case?
It's at
It's a rather long case, you got to tell me where you're reading from.
It's at 327, sir. On the side, there's numbers at 327.
3.27.
327. You see the numbers on the side there.
Alright,
You see 327?
okay.
Starting at paragraph pursuant to section 316.075. Are you there?
Alright, what?
Okay. However, under section 316.0083, which is the Mark Wendell red light traffic camera law, because no one observes the driver, the owner of the car is set notice. The statute then provides a rebuttable presumption that the owner was driving and allows the owner to rebut that presumption. Okay?
How do you rebut it?
Well, I rebut it by saying that it wasn't me driving. My license was suspended at that moment, on that day actually, in question. So there's actually no way that I would have been driving the car. I did have people, including my wife, that were driving me back and forth to work, but I looked in the Mark Wendell statute as well as the other state statutes, and I find nowhere in it that requires me to keep a log of who drives me back and forth to work. No, does it have a legal requirement for me to file an affidavit and do the police's job of finding out who drove the car for them?
The third section, 316.075, law enforcement officer has to observe the violation, who then tickets the driver. However, under section 316.083, because no one observes the driver, the owner of the car is sent to notice. The statute provides a rebuttable presumption of illegal driving, allows the owner to rebut that presumption. For this reason, no point for offense, so you can't get points on it. And that's the reason that is, you don't have to read the order. You go over there and read all the rest of it.
Right.
Because a point of personal, it would not be reasonable for the legislature to impose on person a red light violation, and there is no law enforcement officer present to determine who actually operates in their way. We're not rational basis for the different section 075 is not unconstitutional because of the enforceability of section 316.083. The order is reversed until the amended report is vacated and proceeded for the case.
Right, I've read the case. The important part to notice there was that the statute creates a rebuttable presumption. Okay. Now in 90.302, classification of rebuttable presumptions under 2, a presumption affecting the burden of proof that imposes upon the party whom it operates the burden of proof concerning the non-existence of the presumed fact. Under 90.303, presumption affecting the burden of producing evidence defined, we see in a civil action or proceeding, unless otherwise provided by statute, a presumption established primarily to facilitate the determination of the particular action in which the presumption is applied, rather than to implement public policy, is a presumption affecting the burden of producing evidence. Now, case law on this is very clear. In Davis v. State, we read, circumstantial evidence which leaves uncertain several hypotheses, any one of which may be sound, and some of which may be intact.
In Davis versus State, I don't see anything like that here. I've got legislative part of Barrington, I've got Nielsen versus City of Sarasota, I've got Dixon versus District of Columbia, and California versus Collard. That's the only cases I have, only 4 cases I have.
Let me see what I'll show you.
There's one of them.
You got my brother.
There's the other. There's the other.
I can't.
That's 4.
Okay, I can't see him.
Well, I told you what they were. I told you the only 4 I have is Florida versus Arrington.
Can I see him back?
Sorry. Nielsen versus Sarasota. Dixon versus District of Columbia. And California versus Collard. That's the only 4.
There's one in the paper. You got one in the paper clip? You see the one in the paper clip? Okay, take that paper clip off, fold back 3 pages, you'll find Davis v. State. And if I can see that, I'll actually mark where I'm reading from, that way you don't have to ask them and go look. I'll point it out.
Okay, what are you talking about in Davis versus Florida?
Do you want me to start reading, or do you want me to grab that and mark it so you can see where I'm reading from?
No, you tell me where you're going to start reading from.
Well, I don't actually have the number marked like I did on that last one.
Well, you got it marked on here, or what you're talking about?
It's possible. The paragraphs should start with at the same time.
On what page?
It's the second, I believe.
On the second page.
Yep. The beginning of the paragraph should say at the same
At
time.
the same time, okay,
Okay, here we go. At the same
One,
time.
two, let's see, that paragraph reads, at the same time, we must not lose sight of the basic proposition that one accused of a crime, okay?
Is presumed innocent until proved
Okay.
guilty
All right.
beyond and to the exclusion of a reasonable doubt. It is the responsibility of the state to carry this burden. Okay, it's not the responsibility of me to prove I wasn't driving the car. It's the responsibility of the state to carry this burden. When the state relies upon purely circumstantial evidence to convict an accused, we have always required that such evidence must not only be consistent with the defendant's guilt, but it must also be inconsistent with any reasonable hypothesis of innocence. Evidence which furnishes nothing stronger than a suspicion.
First part of that sentence says, one accused of a crime, you're accused of a crime. This is a civil matter. It is not a crime.
Okay.
That's the reason you don't have a jury for that. Because if it was a crime, you would have a jury.
Okay.
So you don't have a jury, this is not a crime, it is a civil penalty.
Okay, so in the civil case,
let's get to, you tell me what you want, and I'll take all this stuff, and then I'll review it later. Go ahead, get it all in here, tell me everything you want to say.
what's that?
Tell me everything.
It needs to be dismissed. I'll tell you a couple reasons.
I'm going to dismiss it, I'm going to take these, read all these cases first.
Excuse me.
I want to take these cases.
Oh, absolutely.
Well, all right, I can't very well dismiss it if I'm trying to hear, I'm not going to dismiss it, right?
Okay. Well, in closing, there are several reasons to dismiss this case. The main one being that the statute is a bill of pains and penalties. Okay? It's a bill of attainment. Okay? It's a legislative act worked against an individual or easily ascertained group of people, registered owners, that imposes punishment, $158 fine, without a judicial hearing. Because this is administrative. This is not judicial. Okay? That fits to a T the definition of bills of pain and penalties. Okay? It also impermissibly shifts the burden of proof to the defendant and therefore does not afford due process. Due process is notice and opportunity to be heard. This law violates due process by forcing me to forego challenging notice if I contest the violation. Due process also includes the presumption of innocence, which is lacking in this law. Bell v. Burson, 1971, states that my license cannot be taken without due process. That's it.
That it?
That's it.
All right. All right, I'll take the under files and I'll read these cases. And do my research, then I'll make a ruling.
Would that be today or will
Well,
I?
it won't be that way.
Well, how about I find out about this?
Sorry.
How about I find out about it?
You find out when to send you a copy you want. It might be 2 or 3 weeks. I mean,
This is my first time, and I don't know how
you don't think I'm going to run back there now and try to read it, all this stuff, do you?
I have no clue. This is my first time in court here, sir. Well, first time in traffic court, so I have no clue.
You're done, sir. When do I pick that up?
You don't pick it up.
You don't get it
It's
right.
there. It's now there.
I pick it up sooner or later. When do I pick it up?
You don't pick it up.
Is it when the case is dismissed?
You don't pick it up. It is filed with the court. It was part of the evidence. The field will go right along with it. That time. You do not pick it up. I told you why. You're giving it up.
If I don't appeal the case is dismissed, do I pick it up then?
Then that will be up to the clerk's office. They have to come work with them about it. What they do.
What do you mean that's in the court's office? I just forfeit my private property.
Well, it's not your private property when you file it here and you record it.
No, it's private.
And I told you that if you record it,
You can
there's a transcript of the hearing.